Hi, I'm Greg Dell, joined by attorney Stephen Jessup, and we're going to discuss today about long-term disability insurance claims in Florida. And specifically, Stephen, we're talking about the focus of hiring a Florida disability attorney to handle a claim for someone who either lives in Florida or they had jurisdiction in Florida because their employer was in Florida, or some policies say jurisdiction is to be found in Florida, so therefore it requires a lawsuit to be filed in Florida. There's different laws, obviously, that apply in Florida, whether it's a private disability claim, which means not governed by ERISA, or a claim that is governed by ERISA, which is a federal law. But even though it's a federal law, ERISA, the laws of ERISA as applies to disability claims are not the same all throughout the country. So let's talk about the way in which it is for somebody who has a group employer-provided policy, because that's about 90% of the claims that we see, and how, if a claim is denied, how a court's going to look at a claim under the Florida laws with a federal application. So federal court, but Florida type case.
Yeah, so I think, in going back, it's just an ERISA, Employee Retirement Income Security Act, governed policy. And some people call and they say they've denied my claim, I want to sue them. And you can't. You can't just sue an insurance company right away. First, you have to go through the administrative appeal process. So assuming that's done, the claim's been denied, yes, you have to file in federal court. So you're filing in a Florida federal court. And they're going to take a look at, how not only Florida, but the greater circuit. So the federal system is going to be different than the state system. So Florida's in the 11th Federal Circuit Court area. So a lot of times the binding case law isn't just going to be Florida. There'll be Georgia, Alabama, stuff like that. So the courts are going to, any judge is going to take a look at how it needs to be applied here in Florida. For us, under that, we have what's known as, we have a arbitrary and capricious standard of review here in Florida, meaning insurance companies are going to get discretion unless the policy is silent as to discretion. The vast majority, they write the language in. That's going to imply that there's discretion, which means the insurance company gets the benefit of that arbitrary and capricious standard of review. So that's how Florida courts are going to apply it.
When we talk about in Florida discretion, that comes from a discretionary clause. Can you explain what a discretionary clause is and where someone even sees this to determine if it applies to their case?
And that's where Florida is even unique too, because you and I have had cases where it's questionable, but in the discretionary clause, usually at some point in the policy, towards the back when it's kind of going through what I call the housekeeping things about notice of claim, legal actions, it'll say that the insurance company is imbued with the discretion to make final decisions on it. This also will mean sometimes interpretation of plan provisions. So unlike a breach of contract in an individual where if there's ambiguity it's going to be cited in your favor, with these discretionary clauses or authority language put in the policy, the judge has to defer to the insurance company's interpretation of plan provisions. So it's really a very, very powerful tool. You and I recently had a case where it didn't have a clear-cut discretionary clause. But there is a body of case laws. We litigated this that said that even reference to proof sufficient to the insurance company could establish discretion in the policy without it being clearly defined. So Florida is unique in that. Other circuits don't see it that way. It has to be clear as day on it. So if you look through your policy, it's usually towards the back of in the end. Some companies will put it in documents that we argue aren't actually part of the plan documents or the policy itself, so it can get very convoluted. But I would say as a general matter of course, just assume that if you have an employer-provided policy, Florida, you're going to have an arbitrary and capricious standard review. The insurance company will have discretion.
So dealing with that arbitrary and capricious clause, which can be challenging, and when you hire a Florida disability attorney, you need to really, even at the application stage or the appeal stage, forget about just filing a lawsuit. That's a whole other animal. But you need to know the laws that you're up against in the future, because you work that into the manner in which you craft and write your appeals, I'm sure.
I tell people that to understand anything, even when they're applying, they're thinking about applying, you have to do a 30,000-foot view of where this could end up, and that's court. So there's an understanding of how the courts are going to look at this case, how they make their decision, and knowing that, how that's going to guide you the entire way through, whether it be the application, certainly the appeal. We've discussed in various videos how important the appeal is and the process of doing that, and also presenting your information without pointing out everything, legally speaking, the insurance company did wrong, so they don't get the opportunity to rectify that on appeal and then claim when you're in court that they weren't unreasonable in their claims process. So there is an art to crafting. It's presenting information in such a way that, if it does get in front of a judge, not only is a judge going to find your insurance company made the wrong decision, that you are disabled, but more importantly, that second step, that the carrier acted arbitrary and capricious, or that they didn't have reasonable grounds or reasonable basis to deny the claim. And I think that's very important for people to know. If you find yourself in court, judge isn't deciding whether or not you're disabled. It's, are you disabled and were they unreasonable?
Yeah, well, first the judge has to determine if you're disabled.
Yeah.
And then, if the judge thinks you're disabled, if the judge says no, you're not disabled, it's over.
It's over.
It just ends. But if the judge does say you're disabled, then the judge has to go and determine, did the disability company act reasonably? And that opens up an entire body of case law, which is hundreds, if not thousands, of cases that have interpreted the standards for what's a reasonable review by a disability insurance company. Whereas in many of our other cases that might be in California, for example, they don't have this arbitrary and capricious standard review. So if the judge determines you're disabled, it's over. So, selecting a jurisdiction is something we always consider. We represent clients all over the country just because, you have the ability to file lawsuits in basically almost any federal court that you want. But having this understanding of the Florida disability law, if that's where a claimant resides, is great. But there's other cases, depending upon where they are in the country, it may be advantageous to still put it in Florida because of the law in that area. And I know in every case that we handle, we look at and say, where's the best place that we should put this particular lawsuit if it goes to that level, because you want to do obviously what's best for the claimant.
There is that matter of trying to figure out those things. And the majority of other states, if you live outside the state, those states will have similar, as Florida does, with some nuances. And even right now in some cases I have in litigation for a client who lives in Florida, the policy is situated in Texas. It says Texas laws govern, and Texas doesn't allow discretion. We're in the process of motion practice arguing that in Florida, the Florida court can apply the discretion because of that. So there are a lot of different layers and understanding of what you can and can't do.
Right. So that was one of the more complicated classes in law school called choice of law, where you file a lawsuit in Florida, but then whose law applies? Is it like you said? Well, the person lives in Massachusetts, but the policy says the law of Texas applies. And then you're in Florida as well because it's federal jurisdiction. So whose law are we going to apply here?
Yeah, it can get very, very complicated.
So we talked about the ERISA governed claims, which is what most people have because they're employer provided policies. Now there's many people who hire us who have policies that they bought from an agent, and that's called an individual or private disability policy. And in the state of Florida specifically, the laws that apply to that are basically a breach of contract. That's the same. But Florida, up until a few weeks ago, had very favorable bad faith laws. And I'm not ready to speak about how those necessarily are going to apply, but the intent of those is to basically significantly limit the ability to bring a bad faith claim. Whereas before, it was a lower threshold to bring the particular bad faith claim. It always was that you had to go to trial first in your disability claim, win the disability lawsuit. Unlike other states where you may try the bad faith and the breach of contract at the same time. It was never like that in Florida. So it was already an uphill burden in Florida to get to bad faith. But now you still have to go through the case, but the thresholds are much higher, almost like a gross recklessness type standard. And the other thing that they did away with, which is going to be very harmful for claimants, is it seems whether or not it's going to apply, because it will potentially be challenged to long-term disability insurance claims, is whether or not the provision for first-party attorney's fees has been stricken. Because if you would have called me 2 weeks ago, and if you litigated a first-party breach of contract, which was, let's just say, Mass Mutual or Berkshire, Florida claim, you win the suit, you get attorney's fees in a private claim. Now, there may be an argument to say, no, first-party breach of contract claims, you're not entitled to attorney's fees. And that is a horrendous law for people in Florida, because in our situation, no, not necessarily, because we offer a contingency fee type arrangement. But there's many lawyers out there who only accept a claim based upon an award of attorney's fees. And claimants are going to have a harder time now potentially finding lawyers, because the lawyers are going to say the law is not providing for a provision for attorney's fees. So the only way that this is going to happen is through a contingency fee arrangement. And usually in the way we help people, which we almost always litigate on a contingency fee basis, which means no fees or costs unless the claimant wins the claim. However, on our shifting back to our group claims, if we prevail, if you win, there's almost always an award of attorney's fees if you win, subject to discretion of the court, and that attorney fee award is going to be offset against any contingency fee that's owed. And in many cases, the attorney fee award can far exceed the amount of benefits that the person's going to get, so that's a great advantage for the claimant. Now, if you have an individual disability claim and there's no attorney fee award at the end, there's no subsidy of the attorney fee, which is really sad and unfortunate law that just recently in 2023 got passed for what I would say is against policyholders. So the legislator at this point was more interested in protecting companies and trying to think that this leads to frivolous lawsuits or whatever their mentality is. And now I think it makes it harder for claimants to get an attorney. But individual disability claims in Florida, breach of contract, still a good jurisdiction depending upon where you end up, and something that I know you've litigated hundreds if not thousands of times against every disability company. So thank you for sharing your information about Florida disability insurance claims, whether it's short-term or long-term disability. We're here to help you. We always provide initial free consultation. We suggest that you reach out to Stephen or myself, and we look forward to the opportunity to speak with you.